Imagine waking up one morning and discovering that the Supreme Court just made two decisions so seismic, so historically unprecedented, that they fundamentally reshape America's political future, its immigration system, and possibly the next several generations. And just when you think the political landscape can't get any more explosive, Marjorie Taylor Greene drops a bombshell. A leaked phone call about the Epstein Files involving Donald Trump. Headlines are flying, pundits are panicking, and millions of Americans are left wondering what's true, what's spin, and what this means for the country they love. Today, we're diving into all of it calmly, clearly, and honestly. By the time we're done, you'll understand why historians may look back at this week as a turning point in American history, and why the media is desperate to shape the narrative before you hear the real story. Let's start with a decision that instantly sent shockwaves across Washington. The Supreme Court just handed down a ruling on a Texas redistricting case that, on its surface, might sound like dry legal procedure. But make no mistake, this decision has the potential to completely alter the balance of power in Congress for the next decade or longer. Here's what happened. Texas, like many states, draws congressional district maps. These maps determine which areas vote together and ultimately who gets elected to represent them in Washington. A few years back, Texas redrew its maps in a way that some argued would benefit Republicans significantly, potentially flipping around 5 districts from Democratic to Republican control. Now, a lower court looked at these maps and said, wait a minute, this looks like racial gerrymandering. You're dividing people up based on race, not just politics. And that's a big deal because while it's perfectly legal to draw maps that favor your political party, every state does it to some degree. You absolutely cannot divide communities based on race. That violates the Constitution. So, the district court struck down Texas's maps and said they couldn't be used. Texas appealed to the Supreme Court. And here's where it gets interesting. The Supreme Court's conservative majority overruled that lower court decision. They said the lower court didn't give enough deference to the Texas legislature's intentions. In other words, the Supreme Court said we should presume that lawmakers are acting in good faith unless there's overwhelming evidence otherwise. The court emphasized that just because a map might have racial implications in its outcome does not automatically mean it was drawn with racial discrimination as the intent. Now, why does this matter to you? Because this ruling doesn't just affect Texas. It sends a signal to every other Republican-controlled state. If you want to redraw your congressional maps to benefit your party politically, the Supreme Court is much more likely to let you do it as long as you can argue your intent was partisan, not racial. And here's the thing. Partisan gerrymandering is completely legal. Always has been. Both parties do it. The question has always been, where's the line between partisan advantage and racial discrimination? For years, that line has worked in a peculiar way. Because certain demographic groups, particularly black voters, overwhelmingly vote for one party, any attempt by Republicans to dilute Democratic voting power could be challenged as racial discrimination. Even if the true intent was purely political, it created an asymmetry. Democrats could gerrymander aggressively in their states, but Republicans had to be more careful because their gerrymandering could always be reframed as racially discriminatory. This Supreme Court ruling changes that calculus. It says, we're going to look more at your stated intention and give you the benefit of the doubt rather than just looking at statistical outcomes. What does this mean practically? Well, heading into the next round of redistricting, which happens after every census, Republican-controlled state legislators now have much more freedom to draw maps that maximize their electoral advantage. Some analysts are saying this could shift control of somewhere between 20 and 40 House seats over the next few election cycles. That's enormous. That's the difference between a narrow majority and a governing supermajority. But there's a second layer to this that's even more significant. The Supreme Court is currently deliberating on a major Voting Rights Act case. The Voting Rights Act has been one of the most important pieces of civil rights legislation in American history, and certain provisions of it have been used to challenge redistricting plans that have discriminatory effects, even if the intent wasn't discriminatory. This Texas ruling suggests the court is moving toward a framework that prioritizes intent over effect. If that becomes the new standard across the board, it could dramatically reshape how redistricting works nationwide. Now, before anyone panics or celebrates too much, let's be clear about what this really represents. This isn't the court inventing new law. This is the court clarifying how existing law should be applied. The Constitution has always allowed partisan gerrymandering. The question has always been about the boundaries of that permission. What the court is saying now is those boundaries should be clearer, more predictable, and less dependent on post hoc statistical analysis of voting outcomes. In a strange way, it's actually bringing more transparency and honesty to a process that has always been political. But if you thought that Supreme Court decision was historic, hold on, because the next one might change the very definition of American citizenship itself. On the very same day, the Supreme Court announced it would hear arguments on President Trump's executive order regarding birthright citizenship. Now, this is one of those issues that cuts right to the heart of what it means to be American, and it's been simmering under the surface of our national debate for decades. Here's the background. The 14th Amendment to the Constitution, passed after the Civil War, says that anyone born in the United States is automatically a citizen. The original purpose was to ensure that formerly enslaved people and their children would be recognized as full citizens, overturning the infamous Dred Scott decision. For over 150 years, that's been interpreted to mean that virtually anyone born on American soil, regardless of their parents' legal status, becomes an American citizen at birth. It's called birthright citizenship, or sometimes zuoli, which is Latin for right of the soil. President Trump issued an executive order challenging this interpretation. His order said that children born in the United States to parents who are here illegally or who are here on temporary visas should not automatically become citizens. Predictably, this caused an uproar. Legal experts on the left said it was blatantly unconstitutional that the 14th Amendment's language is crystal clear and C ain't be changed by executive order. They pointed to a Supreme Court case from the late 1800s that seemed to settle the question. But here's what's remarkable. The Supreme Court didn't just dismiss the case. They didn't say, this is obviously unconstitutional. We're not even going to waste our time. Instead, they agreed to hear full arguments. That fact alone tells you something significant. It tells you that at least 4 justices, the number needed to grant review, think there's a real legal question here worth considering. So, what's the argument? Well, Trump's legal team points to the specific language of the 14th Amendment. It doesn't just say all persons born in the United States. It says all persons born or naturalized in the United States and subject to the jurisdiction thereof. That phrase, subject to the jurisdiction thereof, is doing a lot of work. Trump's lawyers argue that it implies a level of permanent allegiance or legal connection. They point out that children of foreign diplomats, for example, don't get automatic citizenship, even if born here, because diplomats aren't fully subject to U.S. jurisdiction. They have diplomatic immunity. The administration's argument goes further. They cite that old Supreme Court case, Wong Kark from 1898, and say, actually, if you read it carefully, it doesn't establish universal birthright citizenship. It establishes citizenship for children whose parents had established permanent doicil in the United States. The word doicil appears many times in that decision. Doicil means you've established your permanent home here, that you have ongoing ties and intent to remain. That's very different from someone who crossed the border illegally last month, or someone here on a temporary visa that expires next year. Now, does that argument hold water? Honestly, legal scholars are divided. The traditional reading has been that birthright citizenship is automatic and universal with very narrow exceptions. But there's a counter-argument that we've actually been interpreting the 14th Amendment more broadly than its frame is intended, and that the Wong Kim Ark case was more limited than people remember. And here's the thing that should make everyone sit up and pay attention. Even analysts on networks that are typically very critical of Trump have acknowledged that his legal team has a stronger argument than most people initially assumed. When you hear mainstream commentators saying, I don't think they'll win, but they have a real case. That should tell you this isn't frivolous. The Supreme Court is going to seriously wrestle with this question. Why now? Why is this coming to head in 2025? Well, part of it is the sheer scale of illegal immigration over the past several years. Estimates suggest that somewhere between 15 and 30 million people entered the country illegally during the previous administration. Many of those individuals had children after arriving. Under the current interpretation, all of those children are American citizens. That creates enormous practical and political implications. It affects everything from social services to voting rights to future immigration policy. But there's a deeper reason this issue has reached critical mass. The American people are starting to ask hard questions about sovereignty and citizenship. For generations, we've operated under a framework where citizenship was relatively easy to obtain if you could physically get here and have a baby. That's actually highly unusual globally. Most countries don't have unrestricted birthright citizenship. Canada does. A handful of others in the Americas do. But most of Europe, Asia, and Africa require at least one parent to be a citizen or legal resident. So the question the Supreme Court is really being asked to answer is this: does the Constitution require universal birthright citizenship? Or does it allow for a more nuanced approach that takes into account the legal status and permanent intentions of the parents? And if the court decides the latter, if they say Congress or the executive branch has some flexibility here, it would represent one of the most significant shifts in immigration law in modern American history. Think about what that would mean practically. Right now, if someone comes to the United States illegally and has a child, that child is an American citizen. That child can access public schools, government benefits, and eventually sponsor other family members for legal immigration. It creates what's often called a chain of legal consequences from an illegal act. If the Supreme Court upholds Trump's executive order, or even just says, the issue is more complex than we thought, it would remove a major incentive for illegal immigration. People wouldn't be able to secure citizenship for their children simply by making it across the border. Now, I know some of you might be thinking, but that seems harsh. These are innocent children, and that's a fair emotional response. But law has to be built on principle, not just sympathy. The principle at stake is whether a country has the right to define the terms of its own citizenship. Every nation throughout history has claimed that right. The question is whether our Constitution forbids us from exercising it in a reasonable way. What makes this moment even more critical is the connection between birthright citizenship and the broader immigration system. For decades, we've had a system that's been described as broken by people on both sides of the political aisle. We have millions of people waiting in line legally to immigrate, sometimes for years or even decades. Meanwhile, millions of others have crossed illegally and through various means, including having children here, have managed to stay. That creates a moral hazard. It punishes people who follow the rules and rewards people who don't. And over time, that erodes respect for the entire system. The Supreme Court, taking this case, signals that they understand we've reached a tipping point. Whether they ultimately uphold Trump's order or strike it down, the fact that they are willing to reconsider settled assumptions tells you that the legal and political ground is shifting. And here's my prediction. For what it's worth, I think this is going to be a 5-2-4 decision. I think the court is going to say that birthright citizenship is not absolute, that it requires at least one parent to have some form of lawful permanent status. I could be wrong. These things are never certain until the gavel falls. But the tea leaf suggests the court is ready to make a major statement here. And that brings us to something that happened while the entire country was focused on these Supreme Court cases, something that might have slipped under your radar but is absolutely explosive in its own right. Marjorie Taylor Greene, one of Donald Trump's most loyal supporters in Congress for years, went on 60 Minutes and leaked details of a private phone conversation she had with the former president and the subject, the Epstein Files. Now, before we go any further, let me set the stage for you. Jeffrey Epstein was a financier who died in federal custody several years ago while facing charges related to trafficking and abuse. His case involved allegations connecting him to numerous powerful people, politicians, business leaders, celebrities from both parties and all walks of life. After his death, there have been ongoing calls for complete transparency about who Epstein was connected to and what exactly happened. Earlier this year, Congress passed something called the Epstein Files Transparency Act, which mandated that the Department of Justice release all relevant files within 30 days.